So, already we have discussed regarding presidential election and the very impeachment or removal procedure of the President of India as provided under Article 61 of the Constitution of India. And in this video, we would like to discuss President's judicial powers, and those judicial powers could otherwise we called as powers regarding mercy or clemency, and it is provided under Article 72 of the Constitution. The President can or may or shall grant pardons, reprieves, respites, or remissions, or suspend, remit, or commute sentence of death. So, the very particular judicial power provided to the President as regarding pardons, reprieves, respites, or remissions, or suspend, remit, or commute sentence of death regarding those who are held as such under any court martial or under any law in force either enacted under the Union of India or regarding any death sentence as punished under any provisions of law. So, in this power, these petitions of any such convicted person or prisoners, it would be forwarded by the President to the Home Ministry for its consideration. And this provision of mercy and clemency, as we are discussing under Article 72 of Indian Constitution, this idea is also borrowed from the Constitution of United States of America. So the American president has this power of mercy or clemency under Article 2 of the United States Constitution. So this power of the President of India is available under Article 72 on a petition to the President by any convicted person or prisoners, and it would be forwarded to the Home Ministry, and the very Home Ministry would forward it to, if it is pertaining to any state government. So it would require the advice of the Council of Ministers of that state, and otherwise the President would forward to the Home Ministry, and in lieu of that the Home Ministry would forward it to the Union Council of Ministers for their advice, which is considered as cabinet advice. And in regards to that, the President has to act on the advice of the Council of Ministers, as provided under Article 74, Clause 1 of the Constitution, and if the President disagrees with the advice of the Council of Ministers, then he could send again for their consideration, and if again the same thing without or with any modification sent to the President, then the President is bound to act on the advice of the Council of Ministers, as we found under Article 74, Clause 1, as amended in under 42nd Constitutional Amendment Act 1976, and also under 44th Constitutional Amendment Act 1978. So, in relation to the power of mercy and as such granting pardons, respites or remissions, suspend, remit or commute sentence of death in case of governor of a state, the very provision is provided under Article 61 of the Constitution, and in that case, the governor has no power to commute any sentence of death or in relation to any other such power. Those who are convicted by a court martial. So, in that connection, we would like to discuss certain important leading cases. One is Maruram versus Union of India, decided in 1980. Also, Kher Singh versus Union of India, decided in 1989, and also Mahinder Singh versus State of Punjab in 2013, and all these leading cases decided by the Supreme Court, where it was the observation of the Supreme Court that this very power is primarily a matter of discretion of the President. So the court should not interfere with his actual decision of the President. So also the courts have limited power of judicial review, and also the President can exercise this power, examine the evidence as fresh, and also in regards to that in particular in the leading case Maruram versus Union of India in 1980, Supreme Court upheld that the power of the President under Article 72 is not subject to judicial review, and the President has to act only on the advice of the Council of Ministers. And in regards to Kher Singh versus Union of India in 1989, Supreme Court pronounced that there is no question of any oral hearing by the President. So there can make any evidence express take different view than the court if President so desires. So also President's power under Article 72 relating to pardons, reprieves, respites, or remission, suspend, remit, or commute sentence of death are not subject to judicial review only when it is arbitrary, irrational, malevolent, or discriminatory. Then the court can make its observation. So, in that case also, it is pronounced that the Supreme Court has limited jurisdiction over the power of the precedents regarding granting pardon, reprieves, respites, or remission, suspending any sentence or remit or commuting any sentence of death, and in regards to Dhananjay Chatterjee versus State of West Bengal in 1994, Supreme Court clearly pronounced that the President has to act on the advice of the Council of Ministers. So, in regards to that, also in relation to President's power in relation to mercy or clemency, would like to discuss some other important leading case like Dhirendra Pal Singh Bular versus State of National Capital Territory of Delhi in 2013. The Supreme Court held that, in particular, while exercising power under Article 72 of the Constitution, the President is required to act on the aid and advice of the Council Ministers, as it was also decided in the leading case Kher Singh versus Union of India, also in the leading case Dhananjay Chatterjee versus State of West Bengal in 1994. And now we'll go to another important leading case relating to President's judicial power, that is B. Sriharan versus Union of India in 2014. Supreme Court expressed that the clemency procedure under Article 72 and 161 of the Constitution provides a ray of hope to the condemned prisoners and his family member. Therefore, it is to be exercised within reasonable time. And now we'll go to analyze another important leading case, that is Yaqub Abdul Razak Menon versus State of Maharashtra in 2015. Supreme Court expressed that minimum 14 days is to be granted before the execution of death warrant from the date of communication of rejection of mercy petition to the accused, but no period can be granted if it is a second mercy petition. So we'll discuss another important leading case relating to this provision is State of Haryana versus Jagdish in 2010. Supreme Court expressed that in relation to this particular provision that if an accused convicted to life imprisonment, then the sentence of life imprisonment does not automatically expire at the end of 20 years, including the remission, because the administrative rules framed under various jails, manuals, or under the Prisoners Act cannot supersede the statutory provisions of Indian Penal Code, and the same observation was also made in another important leading case, and that is State of Gujarat versus Lal Singh in 2016. And now we'll discuss another important leading case decided in 2005 by the Supreme Court, and that is Ipuru Sudhakar versus State of Andhra Pradesh, where the Supreme Court pronounced that without application of mind or malafide or irrelevant consideration, or if it suffers from arbitrariness on the part of the President while rejecting any such application or petition by any convicted prisoner or any person so convicted for any imprisonment or in relation to any death sentence. If the very petition or application of that convicted person is rejected without application of mind or malafide or irrelevant consideration, or if it suffers from arbitrariness, then the judiciary or the Supreme Court could interfere to find out those grounds on which the petition was rejected by the President. And we will discuss another important leading case, that is Union of India versus B. Sri Haran in 2015 as regarding to the petition to President on the act of the President and on the very advice of the Council of Ministers relating to clemency or any mercy petition tendered before the President. It is being ruled or pronounced by the Supreme Court in this important leading case, Union of India versus B. Sri Haran, that a person convicted of any offense and sentenced to death under any law relating to a matter to which the executive power of the state extends can approach either the governor by virtue of Article 161 or the president in terms of Article 72, Clause 1, Subclause C, but as regarding that there would be one main provision relating to that the president could act or exercise power under those referred articles as relating to the exercise of power under sections 432 and 433 of the Code of Criminal Procedure is available to the appropriate government even if it is availed earlier and exercised under Article 72 of the Constitution by the President or under Article 61 by the Governor, as it was pronounced by our apex court in 2015 in this important leading case, Union of India versus V. Sri Haran. So, this very particular pronouncement of the Supreme Court provided that even after exercise of the provisions of Article 72 or Article 161, there is another opportunity to exercise of power under section 432 and 433 of the Code of Criminal Procedure. According to the code is available to the appropriate government. So, in relation to President's judicial powers as called as martial clemency as provided under Article 72 of the Constitution of India in relation to how to act as provided under Article 74 Clause 1 regarding to act on the advice of the Council of Ministers and so also the very power of governors as provided under Article 161 relating to those convicted under Court Martial and how it is different from the President's pardoning power under Article 72, and in relation to that we have discussed some important leading case, that is Maru Ram versus Union of India 1980, Kher Singh versus Union of India 1989, Mahinder Singh Paul, Mohinder Singh versus State of Punjab 2013, Dhananjay Chatterjee versus State of West Bengal 1994, so also some other important leading case, and one of the last most important leading case that we have just now discussed relating to the President's power and the Governor's power as provided under Article 72 and Article 161 respectively in relation to the provisions under Section 432 and 433 of the Criminal Procedure Code. That also we have touched with the very pronouncement of the Supreme Court. So, this all that we have discussed in relation to President's judicial powers are sufficient to answer any question pertaining to President's judicial powers. So, this should be sufficient answer in relation to those questions asked in either in 3 year or in 5 year LLB examinations or in any judicial service examinations relating to explanation and enumeration or elucidation of the President's judicial powers as provided under Article 72 of the Constitution of India.